You all got an email from me last night, somewhere a little after 9. I stayed late and went ahead and did the verdict charges for 2 reasons. Number one, I just didn't want to have to do this while y'all were having the trial in case y'all needed me. I also thought today might move a little faster, and so I wanted to make certain I got ahead of y'all of that. And we all know that I'm one step away from beating my machine back there, the printer with the sledgehammer, and so I wanted to go ahead and make certain that I had the ability to print it this morning, so if something went wrong, you could get help early, because my nightmare scenario is y'all sit around waiting for me for an hour again. I don't have any other housekeeping. Any other housekeeping from the plaintiff before we step into your last witness?
No, Your Honor. Do we have anything?
No, Your Honor.
No.
All right, so y'all please look at the charges. I just realized I have enough fun up here. Let me go. I just can't. Let me go. Okay. Anything from the defense?
No, Your Honor.
Okay.
No, Your Honor.
All right. Then, you got your witness out there. It's
Yes.
a live witness, right?
Yes, Your Honor.
That's the guy that drove up?
Yep.
All right. If, Margaret, if the jury is ready, they may come on out. And y'all look at these ruthlessly because I was tired when I typed it. So,
Yeah, I see that you corrected some typos in this copy too.
yeah, I saw several. As soon as I sent it, I was like, it's too late, I'm going home.
Yeah.
All right. Welcome back, everybody. Again, thank you for being now the most punctual and the most efficient jury that I've ever had. So y'all are amazing. I just want to say thank you on behalf of so many people you'll never see and everyone that you see here. Y'all have been attentive, you've been punctual, you're very good at getting out of the jury box. I just want to say thank you for all of that and so much more. If you all remember, we're in phase 2. I told you this would go a lot faster. I believe the plaintiff, is it okay for you have one more, maybe one more witness?
Yes,
Maybe,
sir.
maybe a little more, just one more. So they're almost finished. And so these are all going to go a lot quicker as we go. So at this time, do you have your next witness ready to call?
Yes, Your Honor. Plaintiff calls J.P. Gingras.
Okay. Is it Mr. Gingras?
Gingras, yes.
Okay. Well, Gingras is on his way in. You have your phones in your pockets, purses, or pouches. Make sure they're off at this time. And we'll get started. Thank you. All right. Good morning. You may come on.
Mr. Gingras, could you raise your right hand? Do you solemnly swear or affirm that the testimony you'll give in this case will be the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
Okay, have a seat, please.
Thank you.
All right. And if you'll just make certain to lean into these microphones, they get louder when you get closer.
Could you state your name for the record, sir?
Yes, my legal name is Jean Pascal, Jean-Pascal. I obviously go by JP, and Gingras, Gingras.
Where do you live, sir?
I live in North Atlanta, so Alpharetta, Georgia.
What's your occupation?
I'm a forensic accountant.
What does that mean?
So what it means is that I'm routinely hired by plaintiff's counsel or defense counsel to either help attorneys understand complex transaction in terms of business transactions or calculate economic damages and personal injury matters like I've been asked in this case to do.
What is meant by the term economic loss?
Sure. So in terms of injury, you have two types of damages, economic damages and general damages. Economic damages are those damages that can be valued in terms of dollars. So in personal injury matters, it can be lost wages, lost benefit, the loss of household services, and the future cost of the medical life care plan, all at present values.
Can you just slow down for me a little bit?
Yeah,
It's
seriously.
been a long.
I'm so sorry.
We've been at this for 2 weeks, so we're all moving at about 75% speed, so.
I apologize.
All right, you ready, Mr. Gingras?
Absolutely.
You, ready? Okay. Did I ask you to evaluate the economic losses or damages suffered by Lewis Bennett related to his lost wages?
Yes.
Did I ask you to evaluate the economic losses or damages suffered by Mr. Bennett related to his lost benefits?
Yes.
Did I ask you to evaluate the economic losses or damages suffered by Mr. Bennett related to the present value of his life care plan?
Yes.
And were you able to determine what those economic losses or damages amounted to?
Yes.
All right. Is economic loss the same as human damages or pain and suffering, that type of thing?
No. So economic damages are, again, the damages that can be valued in terms of dollars. I normally explain that to my student in a specific way. Let's assume that I have an injury and I have to go to the physical therapist. The cost of having someone work with me as a physical therapist, I can value that in terms of dollars. Maybe it's $150 an hour or $250 an hour. What cannot be valued is I don't want to do this. I'd rather do something else than have someone work on my injury, and that hurts. Those types of damages are excluded from my testimony today.
And are you here to tell about your conclusions regarding the economic damages to Mr. Bennett?
Yes.
Let's begin talking about your, how you became a forensic accountant. And did you start out as an accountant before you became a forensic accountant?
I did. So I went to school at St. Bonaventure University, which is a small school upstate New York. And I came in Atlanta. I worked for Deloitte & Touche, and I became a CPA in the year 2000. So I've been licensed CPA in the state of Georgia from the year 2000, and I progressed through the normal accounting career. Then I was hired by a law firm in Atlanta, a large law firm, Alston & Bird, which I was in effect an in-house accounting expert. And then I transitioned to the Gingras firm, which is my firm, and I provide services in terms of litigation and non-litigation matters, but related to accounting. So that's why I'm a forensic accountant. Forensic simply means suitable for a court of law. So it is my belief that I should understand sky-high level the law in terms of presenting evidence at trial.
And could you explain, you talked about, your accounting sort of at the corporate level, I guess, and then there's CPAs that do individual taxes. Could you talk about accountants and the various types?
Sure. So in terms of personally, I have 6 certifications. So I'm a certified public accountant, and I tell my students, I'm a professor at Oglethorpe University, that is the greatest certification in terms of normal, not post bachelor's. If you want to be a doctor or a lawyer, fantastic. But in terms of a CPA. But I'm also a certified fraud examiner. I'm certified in financial forensics. I'm a certified financial crime specialist. I'm a certified global management accountant, and I'm also a certified forensic certified public accountant. That certification is given by the AICPA, and we'll talk about what that is, but it is the American Institute of Certified Public Accountants, and that certification is awarded to individuals that have demonstrated an expertise in forensic accounting.
Now we know you went to St. Bonaventure. Can you talk about your education and what you studied in college going forward, please?
Sure. So I was a student athlete. I'm from Montreal originally. I'm an American citizen now, but I was a French speaker. So I started Bonaventure as a French major, and then I had an injury, and I was one of the first of the 5-year accounting program. So the 5-year program would be a BBA and a master's in business administration, or MBA, concurrently. Since I was a student athlete, I had to do it in 3 years. So I could have graduated with an accounting degree, economics degree, finance degree, but I decided to do general business. I believe my certificate simply says a bachelor's of business administration, with concentrations of economic, finance, and accounting, and I also have my MBA.
All right, that's your education. Is that all you need to become a CPA? Can you?
No, in terms of becoming a certified public accountant, I had to pass a series of certification or tests, and I passed all 4 parts in the year 2000, which is when I became a certified public accountant licensed in the state of Georgia.
And how long have you been licensed in Georgia?
So almost 25 years.
And how did you transition from being just a regular accountant to a forensic accountant?
Sure. So when I was hired at Alston & Bird, I dealt mostly with defending securities class actions. So I was helping hand in hand with attorneys in terms of understanding the law and really doing exclusively forensic accounting. And again, forensic simply means suitable for a court of law. So I would say in 2006, which is when I was hired by Alston & Bird, that's where I made the transition from pure accounting, preparing financial statements, to litigation and also non-litigation matters or consulting matters.
You talked about some industry groups. You alluded to them briefly. Can you talk about those and talk about the certifications you received?
Sure. So I have a lot of certification. Some of the certifications are global certification, meaning that, for example, the G7 would recognize them, which that would be the Certified Global Management Accountant. And no certification is specific to the personal injury. They all touch in some sense to the personal injury matter because the methodology is always the same. We're projecting cash flows in the future, reduced to present value. So all these certifications work hand in hand in terms of being able to do these types of calculations.
So in your current practice, how much of your time is devoted to forensic accounting?
Sure, I would say that most of my time, if not 100% of my time, if you exclude the teaching time at Oglethorpe, because I'm a part-time faculty member there. I teach accounting, introduction to accounting there. I would say that most of my time, if not all of my time, is spent to forensic accounting.
And does your work include doing economic damage calculations?
Sure, I do economic damages calculation on a routine basis, and I'm routinely hired by defense counsel or plaintiff's counsel, not on the same matter, but on different matters.
Which side hires you more?
I would say that the plaintiff's counsel retains me more in terms of number of cases. My understanding is that plaintiff has the burden of proof of economic damages. So from my perspective, I see more opportunities. But in terms of revenues, who pays me more? It would be much closer to 50-50, meaning the 50-50 split, because on the plaintiff side is a flat fee arrangement, and on the defense side it's by hour, because it's very unpredictable what the defense could ask me to do, as opposed to the plaintiff, it's very predictable.
All right, now when you're hired, what's your role? Are you an advocate for either side?
Right, so I'm not an advocate for either side, and we'll discuss why I see myself. I think that way. It's very important to see me as a neutral. Whoever would have retained me in this case, whether it was defense counsel or plaintiff's counsel, my methodology would be exactly the same, and my presentation to you would be exactly the same. Because ultimately, my role is to help you decide, after you have determined the facts of this case, what are the value in terms of dollars of those facts. That's how I see my role. So I'm not an advocate for either the plaintiff or the defense. I'm an advocate for my opinion, which would be the same.
You briefly touched on your Oglethorpe University experience. Can you talk about your adjunct professorships, things like that you've done teaching?
Sure. So for 10 years, I was a professor at Georgia State University. Again, I live north of the city, so that was a long commute, but I was there about 10 years. And I decided to focus on my business when Oglethorpe called me and needed help. And I love teaching. If you understand, I was a French major, and an accounting professor helped me transition into being a certified public accountant. And for that, I owe. And therefore, I'm at Oglethorpe University trying to change people's career. And I feel very passionate about that.
Your Honor, at this point, plaintiff tenders Mr. Gingras as an expert in the calculation of economic losses and damages related to the present value of the life care plan, Mr. Bennett's lost income, lost wages, and his lost benefits.
No objection, Your Honor.
No objection, Your Honor.
All right, I will allow the testimony.
Mr. Gingras, let's turn to what you did and how you did in this case. Have you reviewed any documents in this case in support of your opinion?
Yes. So my report would be a Excel spreadsheet, which looks like this. This is a printed spreadsheet. It's Excel based.
Before we go, is that's you prepared a report within your work here with respect to this engagement?
Yeah, so never say always or never, but I always prepare a report in terms of personal injury matters. The report looks exactly the same. It's a discounted cash flow model, and it is Excel based. So that is the printed version of that Excel spreadsheet.
And did you prepare that exclusively for the facts of this case and the data you received in this case?
Yes, the data that I received, I'm making reasonable assumptions because you're the only one that could tell me facts. If I could sit down with you, we would all agree, and I would ask you, what do you see the facts of this case are? I would have one calculation for lost wages, one calculation for lost benefit, and one calculation for the cost of the medical life care plan. Since I can't do that, I have to do reasonable assumptions. So this is my report, and it's an Excel spreadsheet, but I recalculate all the numbers manually to make sure that to reduce the risk of a mathematical error or a grammatical error. So you can see that all these pages have all kinds of annotations to make sure that my calculations are as accurate as possible. Then I have, in this case, I have 12 exhibits. The exhibits are the bases for my assumptions. So exhibit number 1 would be the complaint. I use the complaint to clear conflicts and to assume the date of injury, which in this case is July 1st, 2020. Exhibit number 2 would be a consultation practice aid. This is issued by the American Institute of Certified Public Accountant. The title is Calculation of Damages from Personal Injury, Wrongful Death, and Employment Discrimination. This is the type of guidelines that I follow to the letter to make my calculations. As a CPA, I believe that I should follow the guidelines, and I do so. Exhibit number 3 would be another guideline from the AICPA. This one is titled Measuring Damages Involving Individuals. And again, these are guidelines to not force you to do something, but to tell you, think about how you make reasonable assumptions in matters like this one. Exhibit number 4 would be another guideline of the AICPA. This one is called Attaining Reasonable Certainty in Economic Damages Calculation. Now, of course, my goal in making those calculations is to have reasonable probability of economic certainty. Now here, I'm trying to go one step further. As long as I describe my assumptions to you in detail, you will be able to adjust my assumption to fit the facts of this case as you see them and value those facts with certainty. Nothing more, nothing less. Both plaintiff's counsel and defense counsel should agree on that premise. My presentation ensures that only the facts of this case as you see them are valued. Exhibit number 5 would be the life care plan prepared by Mr. McCord, specifically for Mr. Bennett, and I'm assuming that the life care plan is accurate. Exhibit number 6 would be the normal Social Security Administration retirement age. In this case, I'm assuming that the work-life expectancy would be 67 years old. Exhibit number 7, we'll talk about this exhibit in detail. This is the life table. The life table are issued by the CDC, the Center for Disease Control, and are certified to be used in a court of law. The last page of this document tells you that this has been certified, but I'm making an assumption. Exhibit number 8, we'll discuss in this case that I did not have tax return or W-2, so I had to make reasonable assumptions about the but for the injury. What kind of wages would this individual will be able to earn? I've made 2 assumptions. One is coming from the Bureau of Labor Statistics. The other one is coming from a private source in terms of how much a individual, a truck driver, would make on an annual basis. Exhibit number 9 would be the Bureau of Labor Statistics inflation rate for medical item. And I use that to project in the future the medical costs. Exhibit number 10 would be the U.S. Department of the Treasury, again, an unimpeachable source to create an assumption of my discount rate. And we'll talk about how that applies. Exhibit number 11 would be the difference between lost earnings, the monetary losses, and the difference between the ability to labor. Ability to labor is a general damages. If I wasn't hurt, I could have done this. That is general in nature, and that is simply the Georgia law of damages that differentiates between the two. And again, my testimony is only economic damages, those damages that can be valued in terms of dollars. And exhibit number 12, which is the last exhibit, this is the Bureau of Labor Statistics employer cost for employee compensation. It's reasonable that if an individual earns wages, they will also earn benefits. And I'm using the Bureau of Labor Statistics lowest rate to make an assumption as to the but-for benefits that would have been received. So that would be my expert report and the bases for my assumptions.
All right, this time we would move for admission of Plaintiff's Exhibit 66, the economic analysis and lost wages, lost benefits, and lost earnings for Mr. Bennett as drafted and formulated by Mr. Gingras.
All right, Vince?
No objections, Your Honor.
All right, Stabs?
No objections, Your Honor.
All right, 66, plaintiff 66 is tendered and admitted without objection.
Mr. Gingras, let's talk about Mr. Bennett's lost wages. And as you would like, if you want to refer, we can publish your report on the screen. So if you want to refer to that while you're talking, you just let us know and we'll put it up there.
Great.
But let's talk about his lost wages. What methodology did you use to calculate lost wages?
Right, so the methodology is always the same. We're projecting cash flows in the future. The cash flows, when you talk about lost wages, is but for the injury, how much money would this individual would have earned, but can no longer earn it because of the injury. Now, in this case, my understanding is that you have find liability and causation, so it makes it a little bit easier to discuss these types of calculation. And I've prepared a demonstrative for you to make it easier in terms of when I'm discussing my findings.
All right, you just talked about work-life expectancy.
Yes.
How did you determine his work-life expectancy would have been but for this injury?
Sure. So in this case, we discussed that exhibit number 6 of my report would be the Social Security normal retirement age. I'm simply making the assumption that but for the injury, this individual, Mr. Bennett, would have worked till 67 years old. Again, it is possible that he would have worked much longer than that, or would have worked longer than that, but gaps in employment. For example, it's reasonable to believe that someone would work till 73 years old, but would have 6 years of gap. If you believe that, my calculation would have the assumption that he would have 6 years in gap, because the guidelines tells you that once you have made the determination of the work-life expectancy, let's assume 73, but you have gaps in employment, that you have to collapse it and assume that the work-life expectancy is continuous. So for in this case, I use 67 years old as my assumption for work-life expectancy.
All right, Mr. Gingras, can you walk us through your evaluation of Mr. Bennett's lost wages, please?
Yes, and I've prepared a demonstrative for that.
They're waiting on me, give me just a second.
Sorry.
Okay, there we go.
Great. So that is my expert report. That is simply a cut of my expert report to make it easy for you to follow in terms of my assumptions and how I calculate my scenarios. So you can see here, I have the present value of lost wages, and the beginning of the loss period is January 1st, 2021, which is conservative because I've excluded from the time of the injury, July 1st, 2020, all the way to January 1st, 2021, all of the wage that could have been earned but for the injury are excluded from my calculation. So I've prepared two scenarios. Scenario number one, I've made the assumption, again, in this case, I did not have tax returns, but I've made from the Bureau of Labor Statistics, the median wages for a truck driver is $48,310. And that's what I made as my assumption for scenario number one. So I'm projecting it from January 1st, 2021, all the way to 67 years old, which is 2035 in this case, and reduced to present value. If you believe that the assumptions is too high or too low, it's important for you to understand that my assumption is about approximately 48,000. So if you believe that this individual would have earned 50% more or $24,000 more, meaning 72,000, you would take the 792,000 and multiply that by half to add it to represent a earnings of $72,000. So this is where you can adjust my assumption to fit the facts of this case. So scenario number one uses $48,310, which is coming from the Bureau of Labor Statistics. And my second scenario utilize $86,000, which is the median earnings. I will show that to you. So it's a survey from the Truck Drivers of America that shows that median wages for private fleet is about $86,000. So 48 for my first scenario, 86 for my second scenario, and I'm giving you the average of the two. The average of the two would approximately be $65,000. So that gives you three scenarios, and those amounts are all at present values.
I see your analysis there in the box above the columns has 100% limitation post. What does that mean?
Sure. So in a case like this one, there's always a question about, is this individual capable of earning post-injury? In a wrongful death, I wouldn't have that. But in this case, there's always a question. And it is not for me to make that determination, but for you to make that determination. But if you believe that this individual will never work again, and you believe that he would have earned between $48,000 and $86,000, then the damages, the value of those facts in terms of dollars, will be $1,170,000. But if you do believe that he could earn some money, that becomes a limitation. Let's assume that he earned $100 pre-injury, but now he can earn $80. That would be a 20% limitation. He's lost $20. If you believe that the limitation is 20%, you would simply take 20% of the 1.1 million for 220,000, and so on and so forth. If you believe that it's 50% limitation, this is how you would apply it. So for me my role is to give you what the totality of the economic value is, and you decide if there's a limitation or not.
All right, let's talk about lost benefits. First of all, what are lost benefits?
Sure. So if you assume that an individual works at a company or as a W-2 employee, or even have his own business, it is reasonable that if somebody earns wages, that there are benefits associated to those earnings. In this case, this is my scenario. I'm using the Bureau of Labor Statistics lowest rate. And that was, in this case, I used 41.94% of wages. So that would be my last exhibit. So exhibit number 12. So this, and you can see that the Bureau of Labor Statistics tells you or indicates that the benefits are between 45% and 62% of wages. I use the lowest rate possible, and therefore 45% of the present value of the lost wages would be $332,000 in terms of scenario number one, and of course more in scenario number two. The more you earn, the more reasonable it is to have higher benefits, will be $647,000. But again, you can decide these scenarios are not tied together. You could decide, I believe that this individual would have earned at the average, but would have received the higher benefits. So the scenarios for lost wages and benefits are separated, and I have a demonstrative for you to show how would that work. Okay, so here, this is the category I call lost earnings. Lost earnings are defined as lost wages and benefits. And therefore here, you are not stuck with scenario number one for all. You could decide, well, we believe that scenario number one for lost wages is better representative of the facts of this case as we see them. And we will select $792,000, $792,984 for lost wages. But we believe that the benefits would be higher than what JP says. And we'll take the $647,025. You're not tied to one or the other. You are able to select for lost wages and benefit separately if you decide to do that.
All right, thank you, sir. Have we covered all your demonstratives on lost wages and lost benefits?
Yes.
Okay. Let's turn our attention to the medical life care plan. What method, did you prepare a report of the present value of the medical life care plan?
Yes.
All right, and what methodology did you use for determining the cost of the medical life care plan?
Sure. So here, it is the same method. We are projecting cash flows in the future reduced to present value. Here, the cash flows are the cost of the item included in Mr. McCord's life care plan. I'm assuming that the life care plan is accurate. I'm an economist, not a doctor. And therefore, if I have an item, what is it? If I have a frequency, is it once a month, once a year, and for how long? And a cost in today's dollars, it makes it to my calculation. The only assumptions that I'm making is what is the inflation rate? How much will these costs increase per year over time? A discount rate, if you give me $1 today, what is the interest rate that I could get on that money? And a life expectancy, which is a major assumption.
All right. And can you show us how you performed your calculations?
Sure. I prepared the demonstrative for that. Sure. So life expectancy is a tricky assumption to make, meaning that life expectancy is dynamic in nature. How can I show you that? Mr. Bennett was born on April 29, 1968. On July 1st, 2020, he's 52.17 years old. This is a cut of the CDC life table. So I'm using a reputable source, generally accepted in my profession, to make an assumption of the life expectancy. So you can see that at 52.17, this table tells you that the remaining life expectancy is 27.4, which would give you a total life expectancy of 79.57. But that is the average life expectancy. And it's very important for the jury, you, to understand, is that the right number? Is it too high, too low? How am I going to make sure that I capture 100% of somebody's healthcare needs for the rest of their lives if you find liability and causation, which here you have. So the issue with life expectancy is that as you age, your life expectancy extend. So at 52.17 years, I use the date of the injury. But let's assume that I use the date of this calculation and I use June 16, the start of this trial, to make my calculation. At that point in time, Mr. Bennett was 57.13 years old, 57 years old. The exact same table would tell you that now his life expectancy is 23.4 for a total life expectancy of 80.53 years old. So you can see that in the short period of time, from the date of injury to the date of my calculation, the life expectancy has extended 1 year. Therefore, what the table tells you is not necessarily the life expectancy that you want to select, given that the goal of the life care plan is to capture 100% of somebody's healthcare need. We know that if I use the date of the injury, it is more likely than not that I'm understating the value of the medical life care plan. Well, why? Well, because if I use the date of the calculation, it would be a year longer. And I believe it would be unfair, given liability and causation, that this individual would have to pay for 1 day of his care. But you can go further than that. If my life expectancy is 78, 79, 80 years old, then we can all agree that it is much more likely than not that he would actually attain 76 years old or 75 years old. At 75 years old, if counsel that retained me, or even defense counsel would say, JP, can you update your calculation? Using the same table, my underlying assumption would be 86 years old. Okay, now I'm 6 years undervaluing the medical life care plan. So the life expectancy, it is now because the table tells you something that it is the correct life expectancy to use, given that the purpose of the medical life care plan is to capture 100% of somebody's healthcare needs for the rest of their lives. So that's what I used in my scenario number one.
All right. Now, is this a conservative estimate? How would you characterize that?
Well, yes, as we discussed, if you use the 79, my scenario number one, and we'll discuss it, 79.54, it is more likely than not that you're understating the value of the life care plan. So I've prepared a second scenario. Those life tables are also called mortality table. They're called mortality tables because they tell you the probability of dying every year. Well, as an accountant or an economist, if you tell me the probability of dying every year, I can tell you the probability of being alive. And given that the goal of the medical life care plan is to capture 100% of somebody's healthcare needs, I have calculated what would be 95% certainty. We know the 50% certainty is too low. But what would be 95% certainty that I'm capturing 100% of somebody's healthcare needs? My underlying assumption from the table would be 94.93 years old. Now, of course, I'm not here to tell you that this individual will live till 94 years old. If somebody would tell me this specific individual will live till 92 years old, I would have one calculation and everybody would agree. So I have to make reasonable assumptions. And it is for you to adjust that assumption up or down, but with the backdrop of making sure to capture 100% of somebody's healthcare needs for the rest of their lives. It would be unfair after you found liability and causation for this individual to pay for 1 day of his care.
Objection, argumentative.
I'll have a rule, you can cross.
All right, have we covered everything with respect to life expectancy
Yes.
in your analysis? Okay, before we talk about your calculations, can you tell us how you evaluated his economic losses with respect to the life care plan?
Sure, and again, same process. We are projecting cash flows in the future, reduced to present value. I have three assumptions: life expectancy, inflation rate, discount rate.
All right, can you walk us through your calculations?
Yes, and I've prepared a demonstrative for that. Okay, so this is small, and I'll have another demonstrative for you. But you can see here the number of items that we had in the medical life care plan. Again, if I have an item, what is it? As an economist, I don't need to understand what it is. I just need an item, a frequency, and a cost in today's dollars. It makes it to my calculation. And you can see that I've created ranges. Here, I'm using the 2022 table at 50% certainty. Remember, this would be 50% chance that I'm understating the value of the medical life care plan, and I've proven to you that this column, most likely than not, would understate the value of the life care plan to leave this individual to pay for his own care, which in my opinion would be not in accordance with the present value medical life care plan. The second column uses 95% certainty of capturing 100% of somebody's healthcare needs. And of course, since the life expectancy is longer, it is reasonable that the cost is higher. The longer the life expectancy is, the more expensive the medical life care plan would be. It goes without saying. So I have prepared a demonstrative that summarizes this table. Okay, so you can see here that the future cost of the medical life care plan. Why do I call it future cost? Because I begin on January 1st, 2026. Again, I believe it to be extremely conservative because I excluded anything from today's date all the way to December 31st, and I start on January 1st. Then you have the scenario number one, lower, lower, lower. What does that mean? That means that from the medical life care plan, you sometimes have frequencies, 1 to 2 times per week. The lower would mean for every item in the medical life care plan, I use the lower frequency. The second lower would be lower cost. Sometimes you have 1 to 2 times per week at $100 to $200. For every item, I've used the lower cost. And the third lower would be the lower life expectancy. We talked about 79 years old. And that would be 911,729. And again, using the lower frequency, lower cost, and the lower life expectancy for all items in the medical life care plan. The second scenario would be higher, higher, higher. The higher frequency, higher cost, and higher life expectancy. Again, my life expectancy at that point is 94 years old. And it would ensure that one would capture 95% certainty that I'm capturing 100% of somebody's healthcare needs for the rest of their lives. And the range would be 900 to 3 million for a rounded average. If you believe that it's somewhere in between, would be 1,970,000. And you have the probability of capturing 100% of somebody's healthcare needs with both scenarios.
Mr. Gingras, you use life expectancy as sort of a major assumption, and the jury has a lot of discretion on damages. Can they adjust your analysis to fit what they think the facts fit?
Absolutely. In all of my matters, I'm using the CDC Life table because as an economist, I have to make a reasonable assumption. And these tables are certified to be used in a court of law. But you may want to disagree with that or select.
Your Honor, may we approach?
You may. All right. Members of the jury, at the conclusion of this phase, I will instruct you as to the law on how you shall calculate damages, if any, in this case, and you will be bound by that law. So at this point, I will allow Mr. Scholl to continue his testimony with us.
You were speaking, go ahead.
Sure. So again, I'm using 2 data points for life expectancy. You may want to adjust it up or down. This demonstrative allows you at any point in time. So if you believe that this individual will live till 92 years old, this demonstrative will give you the value of the medical life care plan at that point in time. And again, my role, as I see it, is to educate you as to once you've determined the facts of this case, to adjust my assumption. This table will allow you to adjust my assumption in terms of life expectancy. And of course, you have the lower range, would be lower frequency, lower cost, and higher range, higher frequency, higher cost for all the items. Of course, the first column stops at 79 years old because that's my ending life expectancy for the first scenario, knowing that it is more likely than not that using 79 years old, I'm understating the value of the medical life care plan, given that the goal of the medical life care plan is to capture 100% of somebody's healthcare needs. 94 years old would raise that level of certainty to 95% certainty.
And when you reviewed the medical life care plan and formulated your analysis, did you exclude any elements of the life care plan?
Yes, and I have a demonstrative for that. So this demonstrative lists the item that I've either limited or excluded completely. So again, we discussed that I have to have an item, a frequency, and a cost in today's dollars. So if you see heavy house cleaning, it says at least 1 time per month. As an economist, I'm not going to guess what would be the higher range. I just simply used 1 time per month. But if it was 2, I'm missing 1 time per month, right? Second, home evaluation, at least 1 over lifetime, I used 1. Because again, I'm not guessing what the upper limit is. The complication, any complication, I have an item, I don't have a frequency. How many times is this complication going to occur? And the cost of each item. So I've excluded it, but I've listed them for you to understand that these complications could increase the medical life.
Objection, Your Honor. May we approach?
Yes. Great. Thank you.
All right, proceed, sir.
You may continue your answer.
I'm just waiting for the demonstrative. Okay, so I have 5 items that from the medical life care plan did not make it to my calculation because again, I didn't have a frequency and the cost in today's dollars.
All right, we've covered lost income or lost wages, we've covered lost benefits in the life care plan. We covered everything economics-wise that you evaluated for Mr. Bennett in your analysis.
Yes, and I have a summary demonstrative for you. So this is my summary demonstrative. It has the three elements that I discussed with you this morning. Lost wages, lost benefit. We discussed those, what my assumptions are underlying those two scenarios. We discussed that you could select a lost wages from one scenario and the lost benefit from another scenario. And we discussed the future cost of the medical life care plan in terms of lower, 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 and higher, higher, and you would select which one fit the facts of this case as you see them better.
All right, and your analysis, was it done to a reasonable degree of accounting proficiency, and did you use reasonable practices and standards to come up with this analysis?
Yeah, so I've been in business for about, 15 years now. I've been doing this calculation the exact same way, following the guidelines of the AICPA to the letter.
And are they based on a reasonable degree of economic certainty?
Yes.
All right, I think we're hitting the home stretch here. Before we wrap it up, how much have you been compensated by our office for your analysis?
Sure, so I was retained in 2022, and my total fees over the last 3 years were about $20,000, which for the production of 2 reports, testifying at trial, is routine in terms of a matter like this one.
And have you been paid that amount?
Yes.
All right, Mr. Gingras, is there anything else you want to cover regarding your analysis or anything else that's relevant that you want to talk to the jury about?
Not at this point, no.
All right. Pass the witness, Your Honor.
Ms. Fletcher, cross.
Yes, Your Honor. Mr. Gingras, I was curious because you mentioned it twice in your testimony that you were a student athlete at, say, Bonaventure. That was in tennis, right?
I was a tennis player, yes.
There you go. And then you came from Montreal, so you're French Canadian,
I am French Canadian, yes.
and you majored in French at college.
Well, the first year I was a French major because I didn't think of played professional tennis. I thought I would be at Bonaventure for a year or two and then go back on tour. I tore an ACL, and that's where an accounting professor literally saved my life.
And in terms of forming this report, you said you talked about 12 exhibits that you relied upon, right? We're not going to go through each one, but it was 12, right?
That's correct, yes.
All right. And those 12 exhibits form the basis of your opinions, right?
Yes and no. It creates, if someone would say, well, JP, where did you get this assumption? I would probably rely on those documents.
Yes. And in opening for this damages phase, Mr. Scholl said that economic damages are kind of like supported by receipts, typically. Medical bills, tax returns. Would you agree with that?
No.
You wouldn't agree with that.
Some, yes. Others, no.
Okay, but in terms of calculating what someone is in lost wages over their lifetime, tax returns would be helpful for you, right?
Of course. And I requested those. Unfortunately, they were unavailable in this case, which is not unusual. It happens, but yes.
And it could be unavailable because tax returns weren't filed.
Could be.
All right, and if you don't have tax returns, if they're a regular employee, not an independent contractor, you'd like to see W-2s, right?
Yes.
Yeah. If they're an independent contractor, you'd like to see 1099s.
Absolutely, but 1099s are not determinative because that would show gross revenue, not net income. But yes, of course.
But it would give you an idea of what money they've made over the year, right?
Of course. And as an economist, you would apply the best evidence rule.
Yeah. Now, in terms of someone who drives trucks for a living and is paid by the mileage, if you could get trip sheets or mileage logs to see how many miles they drove and what they were paid, that would be helpful too to see what their income is.
It would be evidence. I don't think I would rely on that because sometimes you have sheets. I would rely, the best evidence rule by ranking would be the W-2, income tax returns, and then maybe other items, but that becomes very low in terms of would I rely on that. If I don't have that, for example, on a minor's case, then I use reasonable assumption from the Bureau of Labor Statistics because some people are just not old enough to have tax returns.
But in Mr. Bennett's case, he didn't have his tax returns, right?
That's correct.
He didn't have his W-2s,
That's correct.
and he wouldn't have W-2s if he testified he's an independent contractor, right?
That is correct.
All right, and if he's an independent contractor, he wouldn't have the job benefits that are similar to those who are regular employees with W-2s, right?
That are similar to W-2s, that is correct, but it would be inaccurate to say that because you own your own business that you don't have benefits. For example, I have my own business, there's no question that it was part of my analysis of not being a W-2 employee. So it's not because you're a sole proprietor that you don't have benefits. And in this case, I'm using the lowest rate possible in terms of the Bureau of Labor Statistics.
Yes, but in terms of calculating lost benefits, you testified that you take 45% or 62% off of those wages.
No,
No, how do you calculate lost benefits then?
sure. So the Bureau of Labor Statistics tells you that the employer cost for employee compensation, which is benefits, are between 45.14% and 61.78%
Of what?
of wages, and I'm using the lowest rate possible.
Based upon an assumption, right?
Of course, it's always an assumption. Even if I had W-2s, it would remain an assumption that but for the injury, it would have earned that kind of money.
No, but
It must be an assumption.
I'm talking about the calculation for the benefits. That is based upon a 45 point whatever or 67 point something of wages, right?
45.14% of wages, that's correct.
And then the wages that you calculated was just based upon a median assumption or other assumptions of what typical truck drivers make, right?
Of course, I had to make a reasonable assumption. It's possible that he would make more. It's possible that he would make less. I have to make a reasonable assumption.
And the best evidence of what that person would make would be the tax returns.
Of course, if I had tax return, I would have used them. If I don't have tax return, I have to make a reasonable assumption. But you can adjust my assumption. If you believe, my understanding is that he testified that he was making $1,000 a week. If you believe that's accurate, that is pretty much my scenario number one. I'm using $48,000 a year, which is very close to $1,000. But you may disagree with that.
So if the tax return showed that Mr. Bennett made much less than your assumption, then all those numbers that we saw in the demonstrative would be less, right?
Of course, it would create an adjustment of my assumption. For example, if the tax return would show up and show 24,000, then you would take my 792,000 divided by 2.
Now let's talk about the life care plan. And you mentioned you make a lot of assumptions because you don't have a lot of information. And you had to take it from Bureau of Labor Statistics or the CDC life table. But with respect to this life care plan, you have to assume that it's correct, right?
Absolutely. I'm an economist, not a doctor. I couldn't possibly tell you if this individual needs anything in terms of medical life care plan. That's why you have a demonstrative that you have all of the items separate. If you believe that one item was not caused by the injury or doesn't need it, you can make that adjustment to my calculation. That's correct.
Did you speak with Mr. McCord?
Don't know if I did or not. I have spoken with him before. I'm not sure if it was about this case or not.
And Dr. Figa, who Mr. McCord said that he approved it, you didn't speak with Dr. Figa, did you?
Of course not, which is typical in a case like this one.
Yeah. Informing your opinions, did you even have any conferences with Mr. Bennett?
No, which is typical in a case like this one. I'm making reasonable assumptions.
Yeah, and whatever conversations you did have informing your opinions, that would have been just with plaintiff's counsel, right?
Again, I'm not sure I had any discussion informing my opinion with counsel. The methodology is always the same. I have assumptions. I knew he was a truck driver. I requested the W-2 and the tax return unavailable, which is not unusual, and therefore I relied on the Bureau of Labor Statistics median wages.
Yes. Now we're talking about the life care plan here. In terms of the life care plan, you had to rely upon the CDC life table, right?
Of course,
Yeah. And I think you testified that it was reputable.
it is certified to be used in a court of law to make an assumption about life expectancy. That's correct.
Correct. But you are relying upon the CDC life table to be accurate as compiled by the CDC.
Well, yes. I've never seen any other economist use a different table to create a life expectancy, but yes, we are all assuming that the table is accurate.
Yeah, and the CDC has been accurate as of late, hasn't it?
Okay, I'm not sure. I'm relying on the CDC life table to be accurate. And again, I'm giving you all the tools to extend the life expectancy or reduce the life expectancy as you see fit.
So without speaking that you recall with Mr. McCord, without speaking with Dr. Figa, without speaking with even Mr. Bennett, and even without speaking with his attorneys to get context, you still billed $20,000 on this case. Is that correct?
Well, of course, which is normal and I believe low when you look at a case where I had a report with a life care plan that needed to be updated. You deposed me, meaning that they interviewed me before trial, and I'm asked to testify at trial. $20,000 in the last 3 years, in my opinion, is very reasonable.
To fill out a spreadsheet, right? $20,000.
That is 29 pages of complex calculations, reference. Yes.
Yes. Now, you, counsel brought this up in their, plaintiff's counsel brought this up in a cross-examination of one of my experts, but you would agree with the principle of data entry, garbage in, garbage out. You ever heard that principle?
Sure. That's why you have to make sure that your assumptions are accurate.
Yes, yes. So the garbage that is in needs to be accurate to make sure it puts out the garbage that is out, right?
Not sure I would describe it as such. My Excel spreadsheet relies on assumptions, and I describe those assumptions in detail so you can adjust my assumptions. I'm not telling you that my assumptions are facts. You determine the facts. My role is to help you decide, once you've determined the facts of this case, how to adjust my assumptions to value those facts with certainty. Nothing more, nothing less. Both you and counsel that retain me should agree on that premise.
Yeah. And you testified and you told this jury here that what you put up there are just ranges or recommendations based upon your analysis, right?
They're not recommendations. Those are calculations that use reasonable assumption, and it is for you to adjust my assumption to fit the facts of this case.
Exactly. It's for them to decide. So if they decide not to accept your calculations, they're within that purview to do that, aren't they?
Of course, you are well within your purview to not follow my calculations. But that's why I explained to you that I believe that my calculations are reasonable, rooted in unimpeachable sources, and have been tested by courts for a long time.
I'm going to object to his testimony. That was purely argument, moved to strike.
You got it on cross.
Yeah.
Thank you, Your Honor.
But they're all assumptions, right?
I must make an assumption. If I did not make an assumption, if I came here and would tell the jury, this will happen, you would be the first one to say, how do you know that, JP? That's why I must make assumptions. Of course, if I could communicate with you, you would tell me what the facts of this case are. I would have one calculation for each element, and everybody would agree that I'm capturing 100% of what you believe the facts of this case are, which is the most important part here.
You didn't ask plaintiff's counsel for tax returns, did you?
Yes, I did,
You didn't get them, right?
which is not unusual in a case like this one.
And you asked for W-2s and you didn't get them.
Of course, I believe it is my responsibility to ask. If they are not present, then you must go to the best evidence rule.
And knowing he was a trucker paid by the mile, you didn't ask for any trip sheets or mileage logs, did you?
I don't think I would ever rely on that.
Even though that shows what they would pay per mile?
Right, then you would have a massive assumption in terms of, okay, well, how many miles a normal or average person make? You would go back to the Bureau of Labor Statistics median wages.
So if there's a document that shows, or many documents over a year, how many miles someone drove and what they were paid for those miles, that wouldn't factor in your analysis?
Of course not, because that would show gross revenues. Then the next question is, okay, how much was gas? How much was expenses? This is gross revenues, which probably, I don't know that, but it's reasonable to believe that the gross revenues would be much higher than $48,000. because you're not counting the cost of gas. You're just counting how much are you paid. So it becomes too complicated. And now I have assumptions after assumptions after assumptions. And if you want to adjust my assumptions, you would say, I don't know how to do that. This is simple. My assumptions are 48,000 and 86,000. If you believe that that is accurate, select that scenario. If not, adjust my assumptions to fit the facts of this case as you see them, ensuring that you're evaluating the facts of this case, nothing more, nothing less.
So even if you had the gross amount earned from driving over the road per mile at 20 cents or 37 cents or 30 cents, you couldn't make assumptions as to what the gas costs were?
Of course, but it's an assumption after an assumption after an assumption.
You didn't do that. You didn't do an assumption of what he spent in overhead on gas, did you?
Okay. No, I did not.
Yeah, that's an
And-
easy answer, no.
And again, I would never do that.
Yeah, you didn't make any assumptions as to what his food receipts would be while he's a driver per year, did you?
No, because that's a benefit. A benefit, this individual, my understanding of this individual was he was on the road all the time. When you talk about benefits, if you're on the road all the time and you eat, that's a tax deduction. And therefore that becomes a benefit, which most W-2 employees don't have that. So you can see the difficulty in terms of being an employee and an owner. Therefore, that's why I'm trying to make it as simple as possible. If you believe he was making more than that or less than that, it is easy for you to adjust my assumption. The more assumptions I make, the more speculative my calculations become.
And you're making the assumption that he was on the road all the time, right?
Of course not. I'm using median wages. If you tell me that, wait a minute, JP, this individual was on the road all of the time, I would say, okay, well, if the median individuals are not on the road all the time, then I would make a speculative adjustment. Say, I think then it's 50% more. You'd be the first one to say, well, how do you know that? That's why I'm not doing that. If you believe testimony that he was making more or less, it is easy for you to adjust my assumption.
But those mileage logs would show how much he was on the road, wouldn't they?
Sure, it would tell
No
me,
further questions, Your
it would
Honor.
tell me how many miles a year he would make, but not what lost wages would be but for the injury.
Any cross,
No, Your Honor.
redirect?
Yes, Your Honor. Mr. Gingras, has Mr. Fletcher's firm hired you to do this exact type of an analysis with the exact methodology that you used for Mr. Bennett?
Of course, I'm routinely hired by defense counsel and plaintiff's counsel. I use the exact same methodology, the exact same type of requests, and same type of exhibits in terms of what do I rely on and how my calculation looks like. It's always the same.
Thank you.
Your Honor?
Good cross.
Yeah.
Can you sit here? You can't tell the jury here that you gave us testimony on a case that was exactly similar to the one that's sitting in this courtroom. You can't give that testimony, can you?
Okay. All cases are different, meaning that this individual is different than any other individual. What is similar, or is exactly the same, is the methodology. It's a discounted cash flow model, and the bases for my assumption. What do I use for wages? What do I use for life expectancy? How do I project in the future, reduce the present value? That is always the same. And it makes sense because it's fair. It allows you to adjust my assumption to fit the facts of this case and value those facts with certainty. Nothing more, nothing less. That's why I'm retained on defense counsel and plaintiff's counsel, because it works.
Any additional cross?
No, Your Honor.
All right, may he, actually, this is good, just sit tight. This is a good spot for a quick break, everybody. So all the rules I've always given you, don't talk about anything, don't do any homework, just sit tight. And step out to the pathway in the hallway and here, knock as soon as you're ready and we'll resume. Again, we've been at it. Correct. None of that goes to the jury. That was just for my own edification. Okay, anybody else?
Present value money, Your Honor.
Yeah, I finally, I got a little bit clearer picture on it, so, okay. Anything else before he goes?
No, Your Honor.
All right, thank you very much.
Thank you, Your Honor.
Again, that was for my own edification, Mr. Fletcher was right, there's no way I should mention that to the jury. I've been at this 2 weeks and I need more coffee. All right, everybody have a quick break, we're off. at, just to go on record, everybody, I was looking at kind of what today looks like, and I was kind of thinking that if I ordered lunch, we might could cut short a little bit. Okay, let's do that. Everybody, so I was thinking slices. I think y'all have all eaten slices. Okay.
Yes.
Will you, James, will you
Did you
lean
go
in
last
and
night?
tell the jurors that I'm,
2 days ago.
that I'm offering to order slices for lunch? And if that's okay with them, if they want something else, that's fine, but if they would like that, I'd like them to go and write their order down so I can go ahead and place it. Because I think if we eat lunch, we might
I think we could finish
finish.
today, Your Honor.
So that's what I'm saying. I think if I feed them lunch, we
I
might
think
be
we
finished today.
finished it.
So,
What's that?
Yes.
Yeah.
okay.
Yeah, I'm missing seeing my son off to Europe.
Oh, wow.
When do you get back?
Okay, so
August.
let's talk shop. So plaintiffs have at arrest. Y'all don't have any witnesses for damages. Everybody got the paper copies this morning and then the email copies last night. Again, I know it was typos. I was tired. But I really wanted to get that to y'all last night. And the good news is, our hero, Matt Middleton with M&H, is in my office right now, standing beside the copy machine in case something happens. So, so I guess I'll officially just call this a charge conference. What did y'all see? What was wrong? What needs fixing? Is there too much? Are y'all in consent of anything I can take out? I'm really just looking for feedback. I mean, do I really need to give all of those charges again? Or, everything that's on page 2, 3? I'm happy to give it for 2, 3, and 4.
I don't think so, Your Honor.
I believe so, Your Honor. I mean, we're relying on testimony as well, you're talking about credibility.
Okay, so you want me to recharge them on it?
Yes, sir.
Okay, anybody who asks gets it. I just want to make certain, so, because all right, then, I'll start with plaintiff. Anything y'all want changed, less, more?
I'm going to accept to nominal damages, Your Honor.
Okay, I saw that coming, that's okay. That is 158 to 163.
Yes.
All right, your exception's noted.
Yeah, we obviously disagree with that, Honor.
It stays.
And just for clarification, the dialogue we had with Mr. Gingras, did that remove page 8 lines 212 through 215, or did I just misunderstand?
Say that one more time.
When we were having the discussion with Mr. Gingras, did we decide we were removing page 8 lines, or just lines 212 through 215, or was that just your clarification?
That was me clarifying.
That was edification.
Just
Yeah,
making sure.
And frankly, it didn't help, so, which is why I was taking math with the juniors, trigonometry with the juniors. I almost got it, but none of that matters for this trial.
Just making sure.
All right, anything else from the plaintiff on the charges? Oh, I do need to fix, line 257. I mistakenly left the word proximate cause. I'm gonna change that over to damages. Remember, I used that charge last phase.
Do you have it? Are there any non-pattern charges in here?
I don't think so. I mean, the implicit bias is a non-pattern charge. I should say that.
Yeah, I hadn't seen that before.
That was in the last charge.
Yeah, it's just something I've done since I got here.
No other exceptions on phase 2,
Yes.
because we got phase 3 as well.
Yeah, well, phase 3 we'll get to in a little bit. So this is just phase 2. All right, Mr. Fletcher.
No exceptions, Your Honor, for transcontinental.
No exceptions, Your Honor.
All right, well then I'm gonna clean this up just a bit. I found a couple other just grammar items and then print this. All right, Mr. Host found a couple things on the verdict form. Let me print that for y'all.
We found a typo? There was a
No,
typo.
I changed it.
Oh, you already changed it.
I did that without adult supervision.
verdict form,
Yes.
the plaintiffs would just accept to there being an option to find in favor of the defendants in this matter, since causation's already been determined. And the extent of the injury goes to the amount of the damages, not whether the jury, the defense can be found in favor.
Okay. Give me just a second, let me see.
Sure.
All right, so, yeah, okay, so, so actually, I was a little hesitant on that myself. What Mr. Hope and I talked about this morning was, for y'all, if it was just one line and had a blank, and then y'all could say, since, it's just that weird dichotomy of, in phase one, they did rule for them, but there wasn't a damages question. So what if it was just a blank and y'all could argue that it's zero? Would that be something y'all would take an exception to, or is that, again, I don't know what y'all prefer. Do y'all prefer zero, or do you prefer a line that says we win?
We prefer what you have here, Your Honor.
Okay. Okay, so let me. Yeah, go do that. I'll print a couple copies. And for record purposes, the jury should be writing out their order for slices, I guess. Did you tell? You told them?
I told them to write it out.
Okay. So we're waiting for them to send something. All right, y'all come get the verdict forms.
How many copies did you make?
A bunch.
Oh,
So they all say KS for kitchen sink.
I
So
wasn't even looking at who I handed that to.
I just didn't want y'all to feel like you had to share a copy.
These are all the same.
Yeah, there's like, I have like 3 copies of each of them.
So this is what you've decided?
No, this is what we're talking about now, that I was back and forth about it, so I asked Mr. Hope to take a look at it, about, since the jury had found for the plaintiff, I was very conflicted about putting a defense line on it. It is phase two, and it is separate, but I felt like the best, after talking with Mr. Hope this morning, and frankly, sleeping on it, I felt like the best compromise position was to give you all full authority to argue, put a zero down. But, I mean, you didn't even argue a zero in your opening. I think you argued, I don't remember what number, it doesn't matter. You argued some number, and so I figured you argued some number, and the jury's already found for them, and those things together made me go, you know what, I really shouldn't put a defense option on there. So that's what's led me to that. And again, that's why I said, if you got really excited last night when you saw it, don't. And if you got really upset last night, don't, because I'm doing this as fast as I can to stay ahead of you.
Well, Your Honor, you're doing a great job calling balls and strikes, and obviously we preferred the first one, and you know, if you decide ultimately to order the second one, we'll take an exception to that and just move on.
Okay. All right. Well then, anything else from the plaintiff on this version of the verdict form that I just passed out?
No, Your Honor.
Okay. Because it also had some language in the original document. No. Okay. No. Yeah, we award.
And Your Honor. Your Honor.
Just one second.
I can resolve our dispute. I think, Lance, I don't think, if the jury's gonna give a 0 in that first line, I don't think a checkbox versus a 0 is gonna make that significant of a difference. I think if it's gonna resolve the dispute with the defense on this and save some time for the court, we're okay with the initial verdict form you sent out last night. But we leave it at your Honor's judgment.
All right, well, since there's consent on that point, I will do that, because, again, if I can get y'all to consent, that's always my best option. So-
Well, Your Honor, after conferring with my much smarter counsel, just the new one you just issued, it would be fine.
Okay.
Just put the instruction back in, please review the jury charge and read the instructions carefully.
Okay.
You've been good about having those instructions in all the verdict forms, and in fact, you have it in the proposed phase 3 verdict form.
Okay, well, y'all pass those back up then, and we'll get you a clean one, and that'll be the final version. I'll shred what I just passed out. Did y'all find anything else grammar-wise or whatnot?
I think defendant or defendants was one of them.
Yeah, I saw those, so. Hey, what do y'all want? I'm ordering enough for everybody. I already said that. Yeah, we're off. What do you want? Slices. What do you want?
No, put the sauce on that. And a sweet tea.
Okay.
What?
All right.
Sweet tea.
What do you want? All right. What do y'all want from slices?
I'll let you
Oh,
guys.
you're asking us?
Yeah, he's
No,
open to us.
I'm fine.
I'm gonna order enough for everybody.
Yeah, I'm fine with the cheese pizza, something with the meat on it, or
Yeah.
just
not
no
very-
olives.
I'm just no veggies. Charles likes mushrooms, sausage.
Oh, Charles.
Yeah, their supreme is excellent.
I take exception to that.
They've got canned mushrooms, so I can't do that.
Oh, that's right.
All right, we've got a couple of cheese pizzas. I'll add an extra supreme. You want an extra pepperoni or anything else?
The old sausage and onion is always good.
Yeah, that's their Supreme. It's excellent. All right. So I got three pizzas for y'all, supreme cheese and pepperoni. Y'all want anything else? For y'all across the board?
No, Your Honor.
No, Your Honor, thank you very much.
We got a former linebacker here, so make sure we have plenty of pizza.
Almost. Always on. Always. They all took a seat. They were dealing with that. I said that one knucklehead. He said, he said 400 every 2 weeks. He said, $50 a week. Every 2 weeks.
We're discussing this one. This is just instead of using the term should be, we changed it. We made that change.
didn't put the instruction.
There just wasn't, I've never seen us use that instruction before, so I kind of just got,
It was in your,
your
phase one version, and then it's
It
on
was
top
like-
of your phase three.
so in the phase one version, we didn't refer to the, well, Joe Sacker put that in here. We've never used that term. I don't know why, where he got that from. I'm not really It wasn't in the phase one.
You're all forced in.
Please review the instructions for the section of the verdict form before completing that section. It didn't refer to the jury charges. So I've never, I just told him I have no idea where he got that, but
Do you have a copy of the phase one?
I will print one. Because this one doesn't have multiple sections, it just didn't seem like there was a need for an instruction.
And you don't need to cut it, we got it.
And because the first draft that we gave out had 2 checks, that was the only reason I could see why the instruction. It just seems redundant to tell them to review the jury charges when we're gonna tell them these are the charges. So, we're about to go talk about it a little bit more. I just wanted you guys to see that before we come back out.
Thank you.
for you to mark up and use in your closing.
Your Honor.
You don't have a verdict form?
Yeah.
All right, pizza's been ordered, it'll be ready at noon. Let me have this. All right, here's two more copies for y'all. If anybody else wants to have a copy, and Alexander is emailing.
Are those just extras?
Yeah, those are extras.
Okay.
And Alexander is emailing those to y'all. All right, y'all need anything else before I become official? So obviously we've tested out the stuff. Y'all ready?
There you are.
Y'all ready to do closings?
Yes, but I am gonna move for direct verdict on damages.
Okay, well, let me throw this in here, become official, and then we'll just make it
I go from 15 to 23 pages, and I'm like, bigger type.
Oh, yeah.
Remain seated but come to order. Court is back in session. Yes, sir.
All right, we're on record. You all have the final version of the verdict form. Each of you have one, and I have the original up here. You also have the final of the jury charges. And just to be very careful, the final date stamp at the bottom is 6/26/25 at 11:03 a.m. So, and the date stamp on the verdict form is today at 10:42 a.m. So, if you have something different, throw it in a trash can and I'll print a new one. Food has been ordered for everybody. They said it'll be ready about noon. So we've got time to do some motions, do closings, and then let them eat.
Your Honor, are you gonna break up closings?
Do what?
Well, it's almost 11:15, and if we do read the instructions and we do closing, rebuttal, I was just asking, is that gonna take us past 12 or?
I'm just gonna go until the pizza gets here.
Okay,
I know that's not normally in a transcript, but there it is.
okay.
So,
Understood.
it's in the transcript. So, one of y'all can appeal that decision. So, do y'all want me to put the jury's lunch order as corpse 4, or do y'all care? I don't have a preference. I just want to be very careful with any communication from the jury.
We don't carry.
All right, well then that will not be corpse 4. We'll got that on the, again, it just says things like pizza, pepperoni, meat lovers, that kind of thing. Okay, then, any motion, anything, any housekeeping before we pivot to the next from the plan?
No, you're on.
All right, Mr. Fletcher, floor is yours.
Forgive me, my mind was elsewhere. What am I?
You wanted to do a directed verdict motion.
Oh, yes, Your Honor. For purposes of the directed verdict motion, we would just like
based upon a renewed objection that the life care plan that was discussed by Mr. McCord and as admitted to him, as admitted by him, was that it was merely signed, and we've heard nothing from Dr. Figa to lay the proper foundation for the life care plan. We moved for directed verdict on future medical care and damages. There is not evidence to support that if you take out the life care plan based upon the lack of foundation that underpins it. And also, no, we're going to stick on just the future medical records. Future medical care has not been proven and should not form any basis for the damages that plaintiffs will be asking for.
Okay. Ms. Dabbs, do you wish to add anything to that before I pivot to plaintiff?
Yeah, just to add some emphasis to that, you know, in order for Mr. McCord to rely on the science and methodology used by Dr. Figa, we have to see that foundation or some form of proper evidence and testimony of that. We've seen nothing. We saw a signature, not even a notarized signature. So at this point, we just don't believe there's a foundation for him to rely, or the jury to rely on that evidence because it's not evidence. So.
Okay, thank you all both. Response from the plaintiff?
Yes, Your Honor, the motion should be denied. This is, Mr. McCord testified, he stayed in his lane about his experience, his expertise. He talked about him projecting costs, which is something doctors don't do. And he looked at that, and his whole life care plan, if you look at every column and every row, it's just about projecting costs using the physician's fee reference. So that's what he did when there were objections. He, you didn't really sustain him, you just sort of gave him instruction to, you know, make sure he stayed in his lane, which he did.
Okay.
So it should be done.
All right, any additional response?
Yeah, only that the projected costs are based upon the care and the recommendations of the physician. We never heard from, nor is there any evidence in the record of that physician commanding that.
All right. I find that by the any evidence standard, which is obviously the decision we make, and obviously, as I've already stated, when I was a defense attorney, I always made a directed verdict no matter what at all stages. I understand your point. I think it's going to be a solid platform for you to use in closing, but as far as the motion, it's denied. So, all right. Then are we ready to move forward until we get pizza here? So, so Kathy's going to get drinks from Kroger. The rest of the team's going down to get the pizzas from Slices. They said it'll be ready at noon. So let's just go. When they get here, we'll take a break, grab a quick lunch. And again, we got enough for everybody who's in the courtroom. There's enough for everybody here. So, all right, you ready, Terry? All right. If you, so as we come out, I will ask you to call your next witness because you haven't officially rested, and then I'll pivot to y'all. And as soon as y'all say you've all rested, I'll tell the jury the evidence is closed. I'll then read this, and then we'll see where we're at, and we'll just evaluate it at each natural stopping point. Y'all need me to do anything different? Or am I messing anything up because we've been at this 2 weeks and I'm losing track of what we're doing? Okay, we're ready then. All right, you all may be seated. Members of the jury, thank you for your patience. While y'all were back there, we got a lot done that would have normally had y'all come out and then go back out. And so I was really pleased with what we've got done. Most important of all, we ordered the pizzas. So, so food's coming. We're going to feed y'all. We're going to feed everybody lunch today so we can keep moving to the best of our abilities. Mr. Scholl, as you'll remember, the plaintiff is presenting their case in chief on damages. Do you have another witness to call?
No, Your Honor.
All right, you rest.
We rest.
All right, so the plaintiff has rested, which means the defense at this moment has the opportunity, but again, no obligation to present evidence in the defense if they wish. Mr. Fletcher, do you have any witnesses to present?
No witnesses, Your Honor.
All right, and Ms. Stabbs?
No witnesses, Your Honor.
All right, so that means that the defense has no witnesses to present,
And we rest.
and you rest.
Yes, Your Honor.
Okay, and then, so that means since there was no, remember there's that rebuttal thing, there's no rebuttal because there was no defense witnesses, which means phase 2 evidence is closed. Remember I told you, we did a lot of talking and got a lot sorted out so that we could move forward. So what that means is we're now pivoting into the last part of phase 2. And so what's going to happen next is the same process we had last time. I'm going to read you the charges. These charges are half the length of the first phase because you have what you need for the rest of it, and you've already made several decisions. I'm going to read this to you. Again, this is my moment to shine. This is the most boring and informative part of the trial where I give you the law. I'm so sorry. I don't know how to read it any more exciting than it is. Of course, you will have a copy. You will have this copy with you in the jury room during your deliberations in case you miss something. So with that said, let's just jump in. Phase 2 regarding damages. This is the final charge to the jury. Members of the jury, you have heard the case of Lewis Bennett as plaintiff versus Eugene Dabbs as administrator of the estate of James J. Evans, Transcontinental Carriers, and Occidental Fire and Casualty Company of North Carolina as defendants. State Court of Spalding County, case number 20 SV 302. The plaintiff has filed this action here in the State Court of Spalding County. The parties will outline their contentions to you in their closing arguments. These are your instructions as to the law that you should apply to the facts of the case as you find them to be. A copy of this charge will be given to you to have with you in the jury room during your deliberations. Instructions for phase 2 regarding damages. As I stated in my preliminary instructions, the Georgia General Assembly recently enacted several changes to how civil trials such as this one are conducted. One such change is that I am now required to present this case to you in multiple phases. We have completed phase 1 regarding fault, and we are now in phase 2 regarding damages, where you have heard evidence related to the question of damages. Parties. As I stated in phase 1 regarding fault, you must consider this case as a lawsuit between people of equal worth and equal standing in the community and between people holding the same or similar positions in life. All people stand equal before the law, and all people are to be dealt with as equals in a court of justice. Business entities such as Transcontinental Carriers Incorporated, Occidental Fire and Casualty Company of North Carolina are to be regarded as people in this instant. Burden of proof and preponderance of the evidence. The plaintiff must prove every essential part of his claim by preponderance of the evidence. This is sometimes called the burden of proof or the burden of persuasion. A preponderance of the evidence means an amount of evidence that is enough to persuade you that the plaintiff's claim is more likely true than not true. In deciding whether any fact has been proven by preponderance of the evidence, you may consider the testimony of all the witnesses, regardless of who may have called them, and all the exhibits received in evidence, regardless of who may have produced them. If the proof fails to establish any essential part of the plaintiff's claim by preponderance of the evidence, you must find for the defendants as to that claim. Under our legal system, it is my duty as the trial judge to determine the law applicable to this case, and it is your duty as jury to determine the facts of the case. It is also your duty to apply the law to those facts in reaching your verdict. Evidence generally. Evidence is how any fact that is put into question is established or disproved. Evidence includes all of the testimony of all of the witnesses, as well as the exhibits admitted during the trial. Exhibits may be either direct or circumstantial or both. In considering the evidence, you may use reasoning and common sense to make deductions and reach conclusions. Direct evidence is the testimony of a person who asserts that he or she has actual knowledge of a fact, such as an eyewitness. Circumstantial evidence is a proof of a set of facts that tend to prove or disprove another by inference. And there's a clerical error. It says set off, and it's supposed to say set of, and I'm initialing and correcting that. If y'all want to do the same, they each have a copy that they have that they're using as well. There is no legal difference in the weight you may give to either direct or circumstantial evidence, and that was on line 71. A different way to explain direct and circumstantial evidence is that direct evidence is the testimony of a witness who has seen or heard the facts to which the witness testifies, and that, if believed, is sufficient to prove or establish these facts. Circumstantial evidence is the testimony of a witness who has seen or heard a set of facts to which the witness testifies, from which such set of facts, if believed, you may find other facts to exist, if such other facts are reasonable and believable to you in light of your experience. When circumstantial evidence is relied upon to establish a fact, it must reasonably establish that other fact rather than anything else. Evidence, failure to produce. When a party has evidence that rejects or disproves a claim or charge made against that party and they fail to produce it, or having access to more certain and satisfactory evidence relies on that which is of a weaker and inferior nature, a presumption arises that the charge or claim is well founded. This presumption may be rebutted, however. Witness credibility. Members of the jury, you must determine the credibility of the witnesses. In deciding this, you may consider all the facts and circumstances of the case, including the witness's manner of testifying, their intelligence, their means and opportunity of knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility as you observe it. Witness impeached. To impeach a witness is to show that the witness is unworthy of belief. The credibility of a witness may be impeached by disproving the facts to which the witness testified. Witness prior statements. Your assessment of a trial witness's credibility may be affected by comparing or contrasting that testimony to statements or testimony of the same witness before the trial started. It is for you to decide whether there is a reasonable explanation for any inconsistency in a witness's pretrial statements and testimony when compared to the trial testimony of the same witness. As with all issues of witness credibility, you must apply your common sense and reason to decide what testimony you believe or do not believe. Witness failure to produce. If a party fails to produce an available witness, the jury shall determine whether such failure warrants the inference that the witness, if produced, would have testified to facts prejudicial to the party failing to produce the witness. Witness experts. When scientific, technical, or other specialized knowledge might be helpful, a person who has special training or experience in that field is allowed to state an opinion about a matter, but that does not mean that you must accept that witness's opinion. As with any other witness's testimony, you must decide for yourself whether to rely upon the opinion. Proximate cause generally. As I stated in Phase 1, before the plaintiff may prevail in this matter, the plaintiff must prove to you, by preponderance of the evidence, that the defendant's failure to exercise ordinary care, i.e. breach, negligence, in the operating of the motor vehicle was the proximate cause of the plaintiff's damages. Proximate cause is a common sense concept, but it has a complicated sounding legal definition. Proximate cause means the cause which, in a natural and continuous sequence, produced an event, and without which cause such an event would not have occurred. To be a proximate cause, the act or omission complained of must be such that a person using ordinary care would have foreseen that the event or some similar event might reasonably occur as a result. When I use the expression proximate cause, I mean a cause that in the natural or ordinary course of events caused the plaintiff's damages. It need not be the only cause, nor the last or nearest cause. It is sufficient if it combines with another cause resulting in the damages. Introduction to damages. We are now pivoting from proximate cause to damages. As a reminder, before the plaintiff may prevail in this matter, the plaintiff must prove to you by preponderance of the evidence that the defendant's negligence in operating his motor vehicle was the proximate cause of the plaintiff's damages. Damages generally. Damages are given as pay or compensation for injury done. If you believe from a preponderance of the evidence that the plaintiff is entitled to recover, You should award to the plaintiff such sums as you believe are reasonable and just in this case. Nominal damages. As I just stated, damages are given as compensation for an injury done, and generally the injury is the measure when the damages are of a character to be estimated in money. If the injury is small or mitigating circumstances are strong, only nominal damages are given. What would be a proper amount of damages is a question for you to decide under all the facts and circumstances of the case. Damages duty to lessen. When a person is injured by the negligence of another, he or she must mitigate his or her damages as much as is practical by the use of ordinary care and diligence. If you believe that a party has suffered damages as alleged under the law, that party is bound to reduce those damages as much as is practical by use of ordinary care. If you believe that by use of such care the party could have reduced the damages, you would determine to what extent and reduce such damages to that extent. Damages medical. In all cases, the necessary expenses resulting from injury are a legitimate item of damages. As to medical expenses, such as hospital, doctor, and medicine bills, the amount of damages would be the reasonable value of such expense as was reasonably necessary. Past loss earnings. Damages past loss earnings. Loss of earnings from the time of the alleged injury to the time of the trial is a legal item of damages, and the amount that may be recovered is the value of the earnings that the evidence shows with a reasonable certainty the plaintiff has lost as a result of the injury. You may consider what the plaintiff was making at the time of the injury, what was made since the injury, the amount customarily paid in the locality for the kind of work the plaintiff does, or similar matters. There must be some evidence before you as to the plaintiff's loss. Damages loss of future earnings. If you find that the plaintiff's earnings will be permanently reduced or destroyed, lost future earnings, just like lost past earnings, are to be determined on the basis of the earnings that the plaintiff will lose, and there must be some evidence before you as to the amount of such earnings. In considering the evidence, you should take into consideration that advancing age typically creates natural limitations that may reduce an individual's capacity to labor and generate income. You may also take into consideration the proposition that the ability of the plaintiff to earn money could have increased during some later periods in the plaintiff's life if it is authorized by the evidence. Damages, life expectancy, and earnings. You may also consider the life expectancy of the plaintiff, average annual earnings. By taking into consideration the factors as to earning capacity and life expectancy and applying them to the plaintiff's life, you should determine what the average annual loss of future earnings probably would have been. Damages, present cash value of future earnings. After you have determined the loss of future earnings, you may reduce the plaintiff's gross loss of future earnings to its present cash value. You would do so by using a rate of interest of 5% per annum as a reduction factor. Life expectancy generally. You may determine the life expectancy of a person when the person's age is shown without any other direct evidence on the subject. In deciding this matter, you are entitled to consider the evidence pertaining to the person's health, habits, surroundings, and method of living. Life expectancy and mortality tables. There have been introduced into evidence a copy of the mortality tables. If you desire to determine from this table the life expectancy of a person, you can look up that person's age in one column, and across from the age column, you will find the life expectancy of a person of that age. Life expectancy shown on any table is merely a guide that you may follow while considering the totality of the evidence. Damages, pain, and suffering. Pain and suffering is a legal item of damages. The measure is the enlightened conscience of fair and impartial jurors. Questions of whether, how much, or how long the plaintiff has suffered are for you to decide. Mental. Pain and suffering includes mental suffering, but mental suffering is not a legal item of damage unless there is physical suffering also. Factors. In evaluating the plaintiff's pain and suffering, you may consider if the following factors have been proven: interference with normal living, interference with the enjoyment of life, impairment of bodily health and vigor, fear of extent of injury, shock of impact, actual pain and suffering, past and future, mental anguish, past and future, and the extent to which the plaintiff must limit activities. Future damages, future pain and suffering. If you find that the plaintiff's pain and suffering will continue into the future, you should award damages for such future pain and suffering as you believe the plaintiff will endure. In making such an award, your standard should be the enlightened conscience of impartial jurors. You would be entitled to take into consideration the fact that the plaintiff is receiving a present cash award for damages not yet suffered. Damages, pre-existing injury and aggravation. No plaintiff may recover for injuries or disabilities that are not connected with the act or omissions of the defendants in this case. There can be no recovery for a particular plaintiff for any injury or disability that was not proximately caused by the incident in question. If you find that at the time of the incident the plaintiff had any physical condition, ailment, or disease that was becoming apparent or was dormant, and if you should find that the plaintiff received an injury because of the negligence of the defendants, and the injury resulted in an aggravation of a condition already pending, then the plaintiff could recover damages for the aggravation of the pre-existing condition. Sympathy. Your verdict should be a true verdict based upon your opinion of the evidence according to the laws given you in this charge. You are not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively without favor, affection, or sympathy to either party. In deciding this case, you should not be influenced by sympathy or prejudice for or against either party because of race, creed, color, religion, national origin, sexual preference, local or remote residence, or economic status. Implicit bias. Additionally, do not decide the case based on any implicit biases. Everyone, including me, has feelings, assumptions, perceptions, fears, and stereotypes. These are implicit biases, which we may not be even aware of having. These hidden thoughts can impact what we see and hear, how we remember what we saw and heard, and how we make important decisions. You are making very important decisions in this case, and you should resist jumping to conclusions based on personal likes, dislikes, generalizations, gut feelings, prejudices, sympathies, stereotypes, or biases. The law demands that you return a just verdict based solely on the evidence in these instructions. Verdict for Phase 2 damages. In issuing your verdict for Phase 2 damages, you shall use the verdict form provided to you by the court. If you believe, by preponderance of the evidence, that the defendant should be awarded damages, you would find for the plaintiff, and the form of your verdict would be, we, the jury, award damages to the plaintiff in the amount of. And then you should fill in the blank provided on that line with the amount of damages that you believe are proper. Once you have completed the verdict form according to these instructions, you have completed your responsibilities in Phase 2 regarding the damages, and you should notify the bailiff that you have reached a verdict. I have stated this repeatedly throughout the trial, but I'm saying again that nothing the court did or said during this trial was intended to hint or suggest to you which of the parties should prevail in this case. Whichever of the parties is entitled to a verdict is a matter entirely for you to determine, and whatever your verdict, it must be agreed upon by all of you. The court's interest in this matter is that the case be fairly presented according to the law, and that you, as honest, conscientious, and impartial jurors, consider the case as the court has instructed you, and return a verdict that speaks the truth as you find the truth of this case to be. During your deliberations, you must not communicate with anyone other than fellow jurors by any means at any time about this case. Additionally, you must not use any electronic devices regarding this case. You must not access the internet in any manner regarding this case, and you must not conduct any research whatsoever about this case until after I accept your verdict. Whatever your verdict in this case, it must be agreed to by every juror. It must be in writing. Please use ink, not pencil. It must be dated and signed by your foreperson. It must be returned and read out loud in court. I will personally read your verdict aloud in open court. Your verdict must be unanimous. And when you get, one of your first duties will be, actually, you've already, sorry, this, remember I said phase 1, phase 2, we're all learning this? I'm about to tell you to elect a 4-person, but you already have. So one of your first duties will be to, I guess, confirm your 4-person who will preside over your deliberations and who will sign the verdict to which all of you freely and voluntarily agree. Start your deliberations in phase 2 with an open mind. You should carefully consider all the evidence of this case and deliberate with an aim towards reaching a unanimous verdict consistent with your consciences and oaths as jurors. Avoid premature fixed opinions. Consult with one another and consider each other's views. Each of you must decide this case for yourself, but you should do so only after discussion and consideration of this case with your fellow jurors. Do not hesitate to change your opinion if convinced that it is wrong. However, you should never surrender honest convictions or opinions to be congenial or to reach a verdict solely because of the opinions of other jurors. At this time, the plaintiff and defendants may each choose to make a closing argument. During closing argument, the attorneys will point to certain evidence and law that they consider favorable to their position, argue persuasively to you, and decide the case in their favor. All parties may choose to make this closing argument. Again, the closing arguments are not evidence, nor is anything the court says evidence. Georgia law provides that the plaintiff may choose to prevent closing argument before, after, or both before and after the defense's closing argument. And I will say again, it is 11:37. We've ordered the pizzas. I'm just going to keep us moving until the pizzas get here and we reach a natural stopping point. So, Mr. Scholl, do you wish to go first, last, or both?
Both.
All right, so the order of events will be the exact same as the previous closing. Mr. Scholl will go first, Mr. Fletcher will go second, Ms. Dabbs will go third, and then Mr. Scholl will go last. We may not make it through all of the closings. We may stop for lunch. I will make that decision as we go. Anybody need anything before we get started? All right, I saw no's across the way. All right, Mr. Scholl, the floor is yours for closing argument.
Thank you, Your Honor.
White screen, Your Honor.
Yes.
Is this okay? All right. Good morning, ladies and gentlemen. This section of the trial and this closing argument is going to be much briefer than the last. There's not going to be as many exhibits and there's not going to be as much argument, but it is very important, even though it's brief, and I hope you will keep that in mind during your deliberations. Now on to damages. Mr. Bennett, his life changed forever on July 1st, 2020. Due to the recklessness of defendants. They disregarded safety rules. Their driver drove impaired down I-75. And after he injured Mr. Bennett, TCI knowingly put him back on the road again. He then totaled his truck on I-75. There was zero remorse. The policy is still there from Transcontinental. They'll accept a medical card up to 2 years old, even if they know it's fake, and they're still operating with those policies in this area. Now, in the interest of your time, we're not going to relitigate everything that was talked about in the first phase. But we trust that you'll keep in mind this recklessness when you're deliberating about Mr. Bennett's damages. So with Mr. Bennett and his damages, we're asking that you balance the scales.
May we approach?
You may. All right, that's sustained. Mr. Scholl, you may resume your closing with these instructions.
Sure, Your Honor. We're asking that you balance the scales, bring him back to even. We're asking for a fair amount for the harms and losses Mr. Bennett suffered since 2020. Now, why does the law allow us to put a price on what he's lost? Because money is the only remedy the law allows. He cannot be made whole by medical science. He cannot have his spinal cord back. So this is the only thing you can do. And that's the way it's been done since ancient times. You can fix, help, and make up for the harms with your verdict. And so we're talking about balancing the scales, balancing what he needs to get by. How do you do that? Like the last phase, you're looking at the evidence through the preponderance of evidence standard. Now, unlike the last phase, you'll have more discretion on certain issues, like the amount of damages. You'll rely on your consciences, guided by the law to reach your verdict. Now, all of Mr. Bennett's doctors have said in this case that his central cord syndrome was caused by the accident. They talked about the permanency of his conditions. I want to go over those steps. Here's what the doctor said about origin of the spinal cord injury. I want to play a few seconds of clips from the doctors. Doctor, can a patient experience organ problems as a result of spinal cord damage from compression?
In his particular case, yes, this electrical cable, the spinal cord does control all things below the brain, including organs. And for instance, his bladder is affected. And so he does have a neurogenic bladder is what it's called, where the bladder doesn't function correctly because the electrical wiring that went to it passing through the spinal cord got damaged. And so, yes.
Doctor, based on his history, his films, your physical examination, and your interaction with Lewis, do you relate his spinal cord damage to the truck accident of July 1st, 2020?
Yes, I do.
Was the truck accident then the reason for Lewis's spinal cord compression, the 2 decompression surgeries, and his present physical and neurological condition?
Yes.
Based on Lewis's medical history and your treatment as Lewis's doctor, did the truck crash where Lewis hit the guardrail cause the neck injury that led to the 2 neck surgeries and all the treatment that you have provided for him?
Yes, I believe so.
Based on Lewis's history and your treatment of Lewis as his doctor and your review of the diagnostic films, is the truck wreck the cause of the spinal cord damage, the cord compression, the bruise on his spinal, and the bruise on his spinal cord for which you have given him the prognosis you have described in this deposition?
Yes, I believe so.
There's 2 types of damages, as the judge explained. There's economic damages and non-economic damages. Now, the economic damages are the damages that are quantifiable, like medical expenses and lost wages. The non-economic damages are the human damages, like pain and suffering. Let's talk about the economic damages first. There's 3 types of economic damages in this case. There's past medical expenses, lost earnings, which include lost wages and benefits, and then the future costs of medical care or the life care plan. We called the 2 professionals to testify, Mr. McCord and Mr. Gingras, and they have impeccable credentials. They are experts that are in this area. All our experts have been either in the Atlanta area or the Macon area, so they're familiar with this region and have given their opinions accordingly based on their experience in this region. Let's look at medical expenses. This is an exhibit that's been introduced. Mr. Bennett's total medical expenses are $488,179 in the exhibit. Now, I want to talk to you about an error that we found yesterday in this exhibit. Dr. Bendix had in his bill, he had charges for Mr. Bennett for preparing for his deposition, for drafting a narrative, things like that. He passed those through on the medical bill. I guess he didn't have a separate bill. And so we found those, and we want to apologize for those in submitting that exhibit. We apologize to the court, apologize to you, and apologize to Mr. Fletcher. So although this says $488, we're going to reduce that by $6,000 because that was the amount that we found. There was no dishonest intent in that. We found that, and we apologize for that error. Now, let's talk about the economist numbers. Mr. Gingras testified, and he testified based on Mr. McCord's life care plan. So the present value of lost wages, we've got it highlighted there. He had scenario 1, scenario 2, and an average. But just on the present value of the lost wages, we're going with the lowest number, $792,984. Now, there was cross-examination by opposing counsel with Mr. Gingras. Mr. Bennett did not have his tax returns. They were not available. Mr. Bennett is an over-the-road trucker. He lives on the road. He comes in during this time, and he slept in a hotel when he needed to. And he just did not have an attic sort of to put those records in and did not have them. So, what he did was he after the wreck, he was basically homeless because he didn't have anywhere to go. He had the surgery. Now, on cross-examination, he talked about how he worked. He said he made $1,000 a week. He said he worked 70 hours a week, worked full-time. And if you remember on cross-examination, Mr. Fletcher asked him for about 5 or 10 minutes about all these jobs he had. And Mr. Bennett explained, look, I'm trying to get the best deal for me. I work for multiple carriers at a time within the rules. And he also talked about how he would just do his best to go for the highest income he could. And so he was being very ambitious, but he doesn't have his tax returns. But there is very ample evidence of what he earned. He worked full time. He earned $1,000 a week. So the scenario one anticipates $48,000 a year. Mr. Bennett testified he made about $52,000 a year, 52 weeks time, $1,000 per week. So there is ample evidence of that. Like I said, we have 4 years he was cross-examined about his work history. And so that's why we're going with scenario one. 52 is closer to 48. 48 is the lowest figure on the Bureau of Labor Statistics for truck drivers. So that's why we came up with scenario one. Now, the lost benefits, we're going with the average between the two for a truck driver, and that's over his lifetime is $489,000. There's been an argument, well, he didn't earn benefits because he was an independent contractor. But anyone who's self-employed knows whether you have benefits or you're self-employed, if you're self-employed, you just pay for that out of your pocket. I mean, I'm self-employed. I don't have vacation time, but if I spend vacation, I just don't make money. And so it evens out either way. And that's why we chose the average on that. Now, as far as the present value and future value of the life care plan, the medical life care plan, we went with the highest number. And we went with that because we don't want Mr. Bennett, he shouldn't run out of money after he reaches a certain age. So we feel that the highest is justified here. Mr. Bennett shouldn't get to a life expectancy of in the 70s or something and then run out of money and not be able to take care of himself. So if there is some play in the numbers, if there is some unforeseeability, the defendant should bear the cost of that because they created this issue. So based on the summary of that, we've got medical expenses of $480, we're adjusting that down. Future medical expenses, the life care plan is $3 million, and lost earnings of $1.282 million. And that includes the lost income and lost benefits. Now let's turn to non-economic damages. So for human damages, there's some instructions that the judge is going to give you, or has given you. But the thing you need to focus on is that it's a lot of this is just in your discretion. They talk about enlightened conscience of fair and impartial jurors. And as jurors, you just have a lot of discretion. You have a lot of power in this case, and it's your call. As far as specific items of pain and suffering, I think the evidence clearly shows that Mr. Bennett endured this language. It applies to his situation, and it's very accurate to describe what he went through. Now, I want to talk about his specific non-economic damages, and I want to begin with his career. He loved truck driving. That was his calling. He's very independent. He's very autonomous, and the solitude of over-the-road trucking, long-haul trucking, was a good fit for his personality. Without his life calling, he doesn't feel as useful. He feels adrift. He's described that. And he feels lost. He doesn't think he has a sense of purpose, and that's very difficult for him. Now, lost mobility. You've seen Mr. Bennett. You've seen him take the stand. He struggles to walk. He struggles to get around. He has spastic movements. I mean, he's shaky and his arms move. It takes a lot of labor for him to get around, just to walk up to the witness stand or walk to the bathroom or something like that. Even with his walker, he can do it better with his walker, but it's still tiring for him. It's painful if he goes too far. He can walk, I think he said, 100 feet or 500 feet. I'm not sure what he said, but it's like a block or something. He's very, very tired and very, very worn out. Dr. Bendix talked about the way he's moving. It affects when he's moving in that way, it affects the adjacent segments of his spine and wears those out. So that's sort of not a good, pretty picture going forward as he gets older and has to deal with that. He's very self-conscious about the way he looks when he walks. He feels that people are staring at him, feels that people may be looking at him. He's talked about his embarrassment in that regard. And one of the two of the biggest problems he has is that he's just really a fall risk. I think you saw that in his video where he was getting around his house. Now, he was able to sort of balance himself on the walls and the doors, but when he doesn't have those, he tends to be unsteady and shaky, and he can fall down. And as he lives by himself, I mean, that could be an issue when he's going up the stairs. He could fall backwards, and it could really be a big issue. Another issue with his lack of mobility is that he can't protect himself really in the event of an emergency. If there's smoke, if there's a fire, he's going to have a hard time sort of escaping that. Now, he doesn't want custodial care. He doesn't need custodial care probably 90% of the time. And the other 10%, he just wants to be autonomous. But he's at risk. He's at risk that he shouldn't be at risk for, and that was caused by the defendants. Now, he did talk about his medications. He's taken several medications. They have serious side effects that he's dealing with. He talked about his nausea medication, or it's in his records. He's taken Zofran. He's taken Zofran since the day of the accident. So he's nauseated a lot. He's nauseated all the time. And anyone who's nauseated knows that is not a comfortable feeling, and to have that for 5 years is pretty ever-present in your life. Now, I want to talk about his lost companionship. And I want to, but first, lost independence. I skipped that one. So we've seen the video. We played the 17-minute video, and it showed him going around his house. I'm not going to replay it. You just saw it yesterday. You know what it says. A picture's worth 1,000 words. You sort of saw him narrate what he's going through. And I hope you please remember that during your deliberations when you think about this lack of independence and the lack of mobility. Now, the loss of companionship. Without the ability to travel very far, Mr. Bennett has become very isolated. He doesn't get to see family and friends in his truck route anymore. And for a man who liked other people to rely on him, he doesn't want to feel that he is a burden. Now, his sister gave very heartfelt testimony about this. He's not confident as far as a significant other. He's impotent, which is humiliating for him, and he feels like less of a man. He has this suprapubic catheter that he described, and I want to just show you an exhibit about that. This is what he's dealing with. You can see it comes out of his belly. It's just an open hole in his body, and this is collected. His urine is collected in a bag that's attached to his leg, and he's got to wear this urine bag everywhere he goes 24/7. So he doesn't go like a normal person. It just flows out, and it fills up this bag. And if the bag gets too full, it'll back up into his system, and that's how he gets infections. So he's got to worry about it when he sleeps, and it wakes him up. He's got to wake up and sort of deal with that. And that's all the time. And infections, when you have a urinary tract infection, it affects your ability to, it affects your mental status. You can have an altered mental status if you have a UTI. That's pretty much common knowledge. And he's had many issues where he's had to go call 911, he's had to go to the hospital, and they've had to take care of this infection. So what's the total amount we're asking for in terms of his non-economic damages? Well, generally, in a case like this, we'll ask for a multiple of his economic damages, and that's in any personal injury case. And the multiple depends on the severity and the extensiveness of his symptoms, and whether they're there all the time, whether they're there for a short period of time, and just however present they are in his life. In this case, so if you had a case where someone was, they were hurt, but they got over it within a few weeks, you may go 1.5 or 2 times their economic damages. But in a more serious case, where it's ever present in their life, they're in a situation where they're feeling it all the time, 24/7, they're in pain, you may go 10 times. The evidence shows that this, for Mr. Bennett, is with him all the time, all day, every day. He's dealing with this. So it is ever present. So we think he should have a higher multiple. what we're saying in this case is economic damages are about 4.5 million. And we're asking you to multiply that by 5 times, and that would be $25 million. Now, that's a lot of money. That's a ton of money. I get it. But it's justified in this case. I don't think I'm exaggerating things to say that this incident has ruined his life. From what he had before and to what he has now, it's just not the same as it was before. And his outlook is very bleak. As he ages, as he gets older, these situations with his body, these infirmities, they're going to multiply. They're going to accelerate. And so I hope you will keep that in mind. Now, Lewis has accepted his fate. He's at a good place spiritually. But we're all, besides your spirituality, besides your spiritual self, you have your physical self, you have your mental self, and you have your emotional self. And he's struggling mightily in those areas. I mean, he's very, very troubled. He's very, very unwell in terms of his physicality and everything else. So he's hanging on. He's hanging on. It's not the life he had before, though. It's not a good quality of life. Now, Mr. Bennett is a regular guy. He's a blue-collar guy. He's not the most important person in the world by the metrics people use, but he's a human being, and his life matters. It matters to him. It matters to his family. We've represented him for 5 years, and it matters to us. And I hope it matters to you in the context of this service, and I hope you see his humanity and have seen his humanity throughout this proceeding. So in the verdict form, we ask that you fill in an amount for damages for Mr. Bennett for the amount of $29,796,000. I'm sorry, $29,796,817 and $29,796,817. That's the right amount. We've been doing this for 30 years, and it's a number I would give for anyone, no matter who they were. This is Mr. Bennett's last opportunity for justice. He cannot come back and relitigate this case. He cannot come back and ask for more money. This is the only trial he will ever get. So just like in the first phase, I'm going to let defense counsel speak now, and then I'll come back and respond to his argument. And I'll address you and close out this phase. Thank you.
All right. Members of the jury, as I told you when we first started this, that I was going to keep an eye on where the food was because I was asking everybody to stick around for lunch. I've just been told from the deputies that the food has arrived. I think this would all go better if everybody had a little food in their belly. So what we're going to do is, so obviously the alternates stay here. Y'all are going to go back in the jury room. The bailiffs will bring you back your pizza and your drinks. Y'all eat. As soon as you're finished eating, knock on the door and let us know that you're ready to resume. Obviously, don't scarf it down. Just eat like you would normally eat, and then let us know that you all are ready to resume. And then remember, there's 4 phases to the closing. And when we come back out, Mr. Fletcher will do his, then Ms. Dabbs, and then you'll hear from Ms. Scholl, and then we'll do the official part. So while you're eating, don't talk about the case or do any homework or use your phones to look anything up. Don't do anything I previously told you not to do. Does anybody have any questions about what we're going to do next? All right, so we're going to take a break. Pizza's on its way back. Y'all enjoy, talk about whatever you want to talk about, but this case. All right, you all may head back to the jury room. If you need anything at all, let the bailiffs know.